Chapter 5, video, or part 10. Now we're talking about evidence still, and any evidence that you present in court, that a party presents, has to be what we call relevant. Relevant in order to be admissible. Relevant means that the evidence sought to be admitted tends to prove or disprove an issue in the case. The key is its relationship to an issue. If it has nothing to do with the issue in the case, then it's irrelevant. Okay? So a lot of times lawyers will try and, for example, show something about the witness that may make the witness look bad. That's okay if it's impeachment. But if it's offered for something as an issue in the case, then it's not going to be allowed unless it actually proves or disproves, or may disprove or prove an issue in the case. Some evidence that's relevant will still be excluded because of the prejudicial effect it might have. So, for example, if you're talking about an automobile accident where where somebody was killed, okay, and they were killed when the car collided, and then it blew up and they burned to death. Okay, so you're now trying to present a picture to the jury of the burned body. Okay, it does tend to prove that the deceased died, and so it is relevant in that way, but it's so highly prejudicial because it will inflame the jury, and there's other ways of proving that same fact that many judges will not allow it. Okay, so this should be probable, or probative, means that it tends to prove something. I'm sorry for that mistake there. So when we use the word probative, we mean that it tends to prove something one way or the other. Okay, now the evidence can also be direct or circumstantial. Direct evidence is defined as the evidence directly proves the fact alleged. Example, Johnny is alleged to have killed Bob. Dave testifies that he saw Johnny shoot Bob and Bob was dead. That's direct evidence, testimonial direct evidence. Circumstantial evidence is indirect. It requires an inference from the facts that were proved. You have to infer from those facts that something else happened. So it requires an inference to be made by the fact finder. Example, Johnny is alleged to have killed Bob. Dave testifies that he was in the room with Johnny and Bob, heard a shot, turned around and saw Johnny with his gun in his hand. Okay? Now, note that both types of evidence are acceptable. Both help to prove something. Obviously, direct evidence carries more weight than circumstantial evidence does. But you can prove a case in either a civil case or a criminal case almost exclusively with circumstantial evidence, particularly if you have a lot of it. So let me give you a scenario similar to what we have up here so that I can explain it a little bit further. So suppose you have Sidney and Ryan, two men in the classroom that I teach. Okay, nobody else is in the classroom. I walk in the classroom and I see Sidney shoot Ryan. Okay, Ryan falls to the ground and he's dead. I'm in court and I testify to what I saw. That's direct evidence. Now let's change the scenario. Again, Sidney and Ryan are in the classroom, and as far as I know, there's nobody else in the classroom. Okay, I'm walking down the hall, about to open the door. I hear what I consider to be a gunshot. I walk in the room and I see Sidney standing over Ryan. Sidney's holding a gun in his hand. Ryan is dead on the ground. I testify to what I saw in court. That's admissible testimony. It is circumstantial. The inference that the jury is asked to draw in that case is the inference that Sidney shot Ryan. Okay? Now the reason that it doesn't carry as much weight is because circumstantial evidence is always subject to the inference, and the inference could be wrong. So for example, Sidney could get on the witness stand and testify, yes, Ryan was very distraught. He was talking about committing suicide, and he had a gun in his hand, and he started to turn it to his head to shoot himself, and I tried to stop it by grabbing the gun but it went off and shot him, and I still had the gun, of course, in my hand as he fell to the ground. Or he could say that Jonathan was in the room with us. Jonathan shot Ryan, put the gun in my hand, and jumped out the window right as you were coming in the room. So that shows you the possibilities with circumstantial evidence. Okay, so examination of witnesses. Of course, the plaintiff goes first and calls the first witness, and that's what we call direct examination. Okay, after the plaintiff's attorney questions their witness, then the defense attorney gets a chance to cross-examine that witness. After cross-examination, there's what we call redirect examination by the plaintiff. Now, redirect examination by law is limited to any issues or things that were raised in the cross-examination. The plaintiff is barred. The plaintiff cannot introduce anything new in the case. You only get one bite of the apple, but you do get a chance to rebut what was shown on cross-examination. And then on recross by the defendant of the witness, the recross is again limited to what the redirect was. So it's narrowing each time, and the judge has a lot of discretion in that area. Okay. All right. So, direct examination is limited to what we call direct questions, and that is open-ended questions. Open-ended questions usually are who, what, when, and sometimes why, or where also. Who, what, where, and sometimes why. Okay, so it's open-ended. Where were you when the defendant was shot? Or who did you see lying on the ground? Okay, that's an open-ended question. Generally, on direct examination, you can only ask open-ended questions. There are a couple or more exceptions. One is where you can show the judge that the witness, even though you called the witness, is actually a hostile witness. In other words, that the witness favors the other side and is going to try and make their testimony favorable to the other side, is not impartial. If you can demonstrate to the judge may let you ask what are called leading questions, which we'll discuss in a minute. The other exception, excuse me, the other exception is if it's a child. If it's a child and the judge determines that the child can testify, because children are sometimes scared and sometimes not easy to get answers from, not because they're lying or anything, just because they're scared or they're not comfortable talking, the judge may allow you some leeway in asking leading questions. Okay. So, on cross-examination, you can only ask what we call leading questions, sometimes also called cross-examination questions. But leading questions is one in which the question contains the answer and usually calls for a yes or no answer. So an example of that would be, you ran through the stop sign, didn't you? Okay. Now, in trial practice courses, they will teach lawyers that when you are cross-examining a witness, you should avoid asking open-ended questions because you give the witness an opportunity to supply information that you don't want supplied to the court. So the general rule on cross-examination is only ask leading questions. Lead the witness through where you want them to go in that path. So let me give you a very simple example of a difference between a leading question and a direct question. So if you put your witness on the stand and you say to the witness, "What is your name?" that's a direct question, an open-ended question. If on the other hand you put the witness on the stand and you say, "Your name is Harry Wilson, isn't it?" That's a leading question. Okay. Now, leading questions in direct examination would usually be objectionable. But the scenario I just gave you, it's unlikely that the judge would not allow that because it's not something that's very prejudicial or controverted, the person's name. So you can get away with some basic underlying questions that are leading even though you're doing direct examination. Okay, so I'm going to stop there and we'll pick up next with part 11.